Suit for recovery of maintenance allowance of the wife is not living with the husband past maintenance allowance fostering period of the child scope. Family court granted the maintenance allowance for the iddat period to the lady plaintiff in wake of her divorce. Family court, though granted the maintenance allowance to the minor girl suckling baby, but denied the same to her mother plaintiff for fostering period on the basis that she had left the house of her husband, not performing her matrimonial obligations, held that though a disobedient lady living separately without any reason should be refused payment of maintenance allowance for that period as she has not performed her matrimonial obligations. But the situation in the present case was different, as the petitioner plaintiff lady had been feeding the minor during such period. Thus, the respondent father of the minor was under obligation to provide the maintenance to her petitioner who was feeding his child. Welfare of the minor is supreme, even if the mother has left her husband's house herself or she is expelled from the house. As per Sharia, the father is duty-bound to maintain his wife, who is feeding his child, and maintenance allowance of such mother cannot be stopped in any way. However, after that period, the court can assess the evidence adduced by the parties, and then appropriate order can be passed under the Islamic law. The feeding period has been fixed by Fiqa as 2.5 years. Therefore, petitioner plaintiff mother was also entitled for the past maintenance allowance from date of her desértion till the time of conclusion of feeding fostering period of the minor, that is 2.5 years. High Court modified impugned judgment and decree to the extent of grant of the past maintenance allowance to the petitioner plaintiff mother for the said period at the rate the minor had been granted maintenance allowance. Maintenance allowance of minor. Enhancement of constitutional petition maintainability. Mother invoked constitutional jurisdiction of the High Court to seek enhancement of maintenance allowance on the ground of daily growing requirements of minor, held that the family court had exclusive jurisdiction to pass an order on the application under S. 151 of the Civil Procedure Code, 1908 for enhancement of the maintenance allowance. Even after the passing the final judgment and decree, petitioner might move the application under S. 151 of the Civil Procedure Code for enhancement of the minor before the court of jurisdiction. WP 18625 of 2016, Farida Babi vs. Judge. Family Court. 2024 meters LD 145.